A seller of real property has certain disclosure obligations to the buyer. These disclosure obligations originate from both common law and statute. The seller's common law duty to disclose a seller has a duty to disclose facts materially affecting the value of the property that are not readily observable and are not known to the buyer. This duty was delineated by the court in Hill v. Jones, 151 Arizona 81, 725 P2D 1115, Appar 1986. In Hill v. Jones, the buyers and sellers entered into a contract for a home with a wood floor. The sellers disclosed no past termite damage, and the termite report indicated no visible evidence of infestation or previous treatment. The termite inspector did not see the treatment holes in the patio because of stacked boxes, and did not find the termite damage inside the house because a large plant covered the area. After close of escrow in the Hill case, the buyers learned from a neighbor that the house had past termite infestation, and the buyers discovered that part of the wood flooring was crumbling. When the lawsuit was filed, the buyers learned that the sellers had received 2 termite guarantees from the previous owner, had treated the house twice for termites, and that existing termite damage had not been repaired. In examining the case, the court announced the seller's duty to disclose material facts to the buyer in Arizona and stated that under certain circumstances, non-disclosure of a known fact may be equivalent to the assertion that the fact does not exist. Therefore, non-disclosure may be equated with and given the same legal effect as fraud and misrepresentation. And, as the Arizona Court of Appeals recently made clear, an as-is clause, provision in a contract, does not shield the seller from liability for failure to disclose known material defects in the property. S. Development Corp. v. Pima Capital Management Co., 201 Ayers 10, 31 P. 3rd, 123, Appar 2002. The seller is obligated to make the required disclosures regardless of the as-is clause. The property being sold is in as-is condition upon contract acceptance. The seller is not obligated to fix any of the mechanicals as in previous years. Of course, the buyers may request items to be repaired, installed, or replaced. Further, if the buyer asks the seller about an aspect of the property, the seller has a duty to disclose the information, regardless of whether or not the seller considers the information material. Universal Inverse Corvi, Sahara Motor Inn, Inky, 127 Ayers 213, 215, 619 P2D 485, 487, 1980. Sellers also have a legal duty to disclose facts when disclosure is necessary to prevent a previous statement from being misleading or a misrepresentation. For example, if something changes. However, a seller does not generally have a legal obligation to correct defects in the property, as long as the defects are disclosed. The seller's statutory duty to disclose. In addition to the common law duty to disclose, there are an ever-increasing number of specific disclosures that sellers are required by statute to make, such as lead-based paint disclosure in pre-1978 properties, Title X, swimming pool barrier disclosure, ARS, paragraph 36, 1681E, PUD condo disclosure information, ARS, paragraph 33, 1806 and 33, 1260, notice of soil remediation, ARS, paragraph 33, 434.01 and 49, 701, 2. Disclosure affidavit for land in unincorporated areas, except subdivided, ARS, paragraph 33, 422. Military airport, ARS, paragraph 28, 8484. Public airport information at ARS, paragraph 28, 8486. Subdivision disclosures, public reports, e.g., ARS, paragraph 32, 2183. The SPDS assists in making these disclosures. The Arizona Association of Realtors, AAR, Seller's Property Disclosure Statement, SPDS, is designed to assist sellers in making these legally required disclosures and to avoid inadvertent non-disclosures of material facts. The first page of the SPDS is a seller advisory to help educate sellers about their disclosure obligations and to assist sellers in completing the form. AAR developed the SPDS 15 years ago to assist sellers to fulfill their disclosure obligations. The SPDS protects the seller by evidencing the seller's disclosure of material facts to the buyer. However, it has been suggested in the past that the use of the SPDS may be detrimental to the seller, resulting in some questions and concern. Following are answers to some of those questions and concerns. Does the SPDS unfairly shift the risk from the listing broker to the seller? No. The seller has an obligation to make the required disclosures regardless of whether the seller is represented by a broker or uses the SPDS. Are all the questions on the SPDS material in every transaction? No. Some of the questions on the SPDS are simply for informational purposes. What is material depends on the facts and circumstances of the transaction. If the seller answers the questions on the SPDS that are not material in that particular transaction, is the seller harmed? No. To coin a phrase, if it is material, the seller must disclose it. If it is not material, why not disclose it? Since every question on the SPDS may not be material, wouldn't it be better if sellers made their disclosures of material fact on a blank piece of paper rather than utilizing the SPDS form? If a seller could remember all the material details of the property that need to be addressed, a writing would suffice. However, the SPDS serves to address statutory disclosures of which the seller may not be aware, to prompt the seller to disclose information the seller may not realize is material, and to assist the seller to make these disclosures fully and accurately. Does the SPDS operate as a warranty of the condition of the property? No. The SPDS is not a warranty, but simply a disclosure of facts of which the seller is aware. The SPDS requires the buyer to acknowledge that the information in the SPDS is based only on the seller's actual knowledge and is not a warranty of any kind. See SPDS lines 286-287. FIRPTE is the Foreign Investment in Real Property Tax Act of 1980. Put simply, this legislation often requires the seller to disclose to the buyer if the seller is not a citizen of the United States. As such, under certain circumstances, the buyer would be required to withhold 15% of the sales price of the property. That's sales price, not equity or proceeds. When FIRPTA does apply and the title company is involved, they typically will prepare the documents, hold the funds, and submit the paperwork and funds to the IRS. As a listing agent, we probably have the obligation when taking the listing to ask the seller if they are an American citizen. Not every real property sale would invoke FIRPTA, but it is best that the title company tell the client that fact, and not you, the listing agent. Certain residential transactions are exempt, for example, if the sales price on the house is under $300,000. And there may be situations where the seller might not be a citizen, but might qualify for an exemption under FIRPTA. Why is this important? Might a transaction fall apart if, when the seller learns that 15% of their sales price will be withheld? For example, the sales price is $600,000 and the seller owns the property free and clear. 15% would be $90,000. That seller might not be too concerned since their net at closing might be about $475,000. But the same seller with a $460,000 loan to pay off might only see about $15,000 at closing. That might change their plans to sell this property at this time. If that were the case, and the seller learned during the listing process, a decision not to sell would not have a negative impact on another party. But if the seller learns of this obligation a week before closing and refuses to close, that decision might have a negative impact on the buyer as well as everyone associated with the transaction. If in fact the seller must comply with FIRPTA, that matter must be disclosed to the buyer. Financially, a seller's obligation to comply with FIRPTA would not impact a buyer. However, as part of that compliance, the buyer would be required to complete certain forms for the Internal Revenue Service. Those forms would require the buyer's personal information, including Social Security numbers. In the age of privacy concerns and the handling of personal data, a buyer should be fully aware that their cooperation would be required. Once a seller understands that they must comply, they might start asking you questions about the money withheld. Specifically, is that $90,000 gone forever? Or might the IRS refund some or all of it? You should not answer that question. While you are obligated to disclose the issue of FIRPTA, you should not answer such a question. That would be the time to refer the seller to a tax expert. At some point during the listing process, the listing agent should ask the seller if they are American citizens, or are they a foreign national. The answer might be an explanation of their status, such as holding a green card, holding a work visa, etc. A licensee should never answer these questions. Once a seller claims that they are not American citizens, they should be referred to an expert regarding their legal status. The expert could be someone at the title company that will handle the transaction. If a seller is obligated to comply with FIRPTA, or if in fact they are exempt, they should hear that from an expert and not a licensee. The seller could also consult with an attorney or accountant to determine if they are obligated to comply with FIRPTA. Another question happens when the seller is a couple, or a partnership, and one person is a citizen, yet the other is not. Would FIRPTA apply if the husband is a citizen of Greece, yet the wife is an American citizen? Probably, since the goal of FIRPTA is to collect any taxes due on the sale of the property. American citizens might have taxes due on the sale of property, and that would typically be reported on a tax return for that year. If the person is not a citizen, they might not file a tax return. A common concern amongst licensees is that asking such a question might violate the seller's fair housing rights. That is not the case. A listing agent has the obligation to determine this fact and should be prepared to disclose the seller's status to a buyer in the listing and again in the purchase contract. Most MLS systems in Arizona have a standard real property listing agreement, and those agreements often contain a clause that the seller agrees to comply with FIRPTA if it applies. And the statewide Arizona residential purchase contract provides the seller's obligation to disclose their status under FIRPTA within the disclosure section. And, in the same contract, the buyer accepts the obligation to determine the applicability of FIRPTA and accepts the tax liability if FIRPTA applies, yet the parties fail to comply. Thus, asking a seller of their status as citizens is not a fair housing violation. It is a disclosure obligation. On the contrary, it is in a few places where you should, as an agent, ask or explain FIRPTA to the seller. Exceptions from FIRPTA. Withholding. Generally, FIRPTA withholding is not required in the following situations. However, notification requirements must be met. 1. You, the transferee, acquire the property for use as a residence, and the amount realized, sales price, is not more than $300,000. You or a member of your family must have definite plans to reside at the property for at least 50% of the number of days the property is used by any person during each of the first two 12-month periods following the date of transfer. When counting the number of days that the property is used, do not count the days the property will be vacant. For this exception, the transferee must be an individual. 2. The property disposed of is an interest in a domestic corporation if any class of stock of the corporation is regularly traded on an established securities market. However, this exception does not apply to certain dispositions of substantial amounts of non-publicly traded interests in publicly traded corporations. 3. The disposition is of an interest in a domestic corporation, and that corporation furnishes you a certification stating, under penalties of perjury, that the interest is not a U.S. real property interest. In most cases, the corporation can make this certification only if either of the following is true. During the previous 5 years, or if shorter, the period the interest was held by its present owner, the corporation was not a U.S. RPHC. As of the date of disposition, the interest in the corporation is not a U.S. real property interest by reason of Section 897C, 1b of the Code. The certification must be dated not more than 30 days before the date of transfer. 4. The transferor gives you a certification stating, under penalties of perjury, that the transferor is not a foreign person and containing the transferor's name, U.S. taxpayer identification number, and home address, or office address, in the case of an entity. 5. The transferor can give the certification to a qualified substitute. The qualified substitute gives you a statement, under penalties of perjury, that the certification is in the possession of the qualified substitute. For this purpose, a qualified substitute is A. the person, including any attorney or title company, responsible for closing the transaction other than the transferor's agent, and B, the transferee's agent. 6. You receive a withholding certificate from the Internal Revenue Service that excuses withholding. See withholding certificates later. 7. The transferor gives you written notice that no recognition of any gain or loss on the transfer is required because of a non-recognition provision in the Internal Revenue Code or a provision in a U.S. tax treaty. You must file a copy of the notice by the 20th day after the date of transfer with the Ogden Service Center, P.O. Box 409101, Ogden, UT 84409. 8. The amount the transferor realizes on the transfer of a U.S. real property interest is 0. 9. The property is acquired by the United States, a U.S. state or possession, a political subdivision, or the District of Columbia. 10. The grantor realizes an amount on the grant or lapse of an option to acquire a U.S. real property interest. However, you must withhold on the sale, exchange, or exercise of that option. 11. The disposition is of an interest in a publicly traded partnership or trust. However, this exception does not apply to certain dispositions of substantial amounts of non-publicly traded interests in publicly traded partnerships or trusts.